Communications are subject to judicial process, even when the president is under investigation, end quote. Vance 140 SCT at 2427, citations omitted. See also Clinton 520 US at 703-05, recounting history of sitting presidents complying with court orders to provide testimony and other evidence. The separation of powers doctrine, as expounded in Marbury and its progeny, necessarily permits the judiciary to oversee the federal criminal prosecution of a former president for his official acts because the fact of the prosecution means that the former president has allegedly acted in defiance of the Congress's laws. Although certain discretionary actions may be insulated from judicial review, the structure of the Constitution mandates that the president is, quote, amenable to the laws for his conduct, end quote, and, quote, cannot at his discretion, end quote, violate them. Marbury 5 U.S. 1 Cranch at 166. Here, former President Trump's actions allegedly violated generally applicable criminal laws, meaning those acts were not properly within the scope of his lawful discretion. Accordingly, Marbury and his progeny provide him no structural immunity from the charges in the indictment. Our conclusion that the separation of powers doctrine does not immunize former presidents from federal criminal liability is reinforced by the analogous immunity doctrines for legislators and judges. Legislators and judges are absolutely immune from civil suits for any official conduct, and legislators have an explicit constitutional immunity from criminal prosecution arising from the speech or debate clause. Nevertheless, legislators and judges can be criminally prosecuted under generally applicable laws for their official acts consistent with the separation of powers doctrine. Legislators have explicit constitutional immunity from criminal or civil liability, quote, for what they do or say in legislative